Over the past decade, class action lawsuits have become much more common and a problem for many businesses. And COVID has only encouraged more class action activity. Rick Bean and Brian Freeze are both partners in the Kansas City office who practice largely in the defense of class action cases and are here to talk about where this practice area is and where it's going. I'll turn it over to Rick and Brian.
Thanks, Gene. And thank you all for participating this afternoon and inviting us into your work from home workspace, whether it's your actual office, your bedroom, your living room, family room, basement, or wherever it may be. It's an interesting opportunity to share our time with you. As the photo on my bio indicates, and my bio, there's a little bit of discontinuity there. I've been defending class actions in a variety of areas since long before that old picture was taken. Mostly in the areas of financial services, consumer protection, healthcare, and ERISA. And Brian, why don't you introduce yourself?
Thanks, Rick. Great to be here with everybody. As you can see from my bio, I've been practicing in the class action area for many years, and it's really taken off the last couple of years. There's so much going on in class actions right now, and we've really seen it manifest itself in the cases that we've been handling and that we've been involved in. And we're excited to spend a little time with you this afternoon talking about all the really exciting things going on in class actions. And so what we want to do is start off by talking a little bit historical and give you some context of why things are the way they are. And then we're going to talk about some of the trends we've seen in recent years, and then really zero in on some of the trends we've seen with COVID. And then all that will come together and you'll see why we've got so many really exciting kind of hot topics that are going on in class actions right now, and why they're so intensely litigated out there, and you've got so many people like us kind of geeking out on all the different court decisions and which way this circuit's going and what are states doing and so forth. And so with that, let's start with the historical piece of it. If we could just briefly go even to the next slide there. Thank you. Let's remember our context here. If we look back at litigation over the last 20, 30 years, we've seen this progression of summary judgment and clarification in federal rules. Then we've seen the Daubert issue come out, and then the Iqbal-Twombly duo that really heightened pleading standards and made motions to dismiss something significant in federal court litigation. And then we've also seen more recently the Bristol-Myers Squibb case come out, and kind of a change in class action or change in personal jurisdiction, and in particularly having some effects in class actions. And then we've also seen a lot of Supreme Court cases over the last decade or so really coming out in the class action arena. And if you could go to the next slide, please. We can highlight some of these. First, we've got the AT&T mobility case, which really put arbitration on the map. It said, hey, look, the FAA, Federal Arbitration Act, is a real act, and we really mean it. You can't just blow it off. This has some teeth to it. And ever since then, we've seen kind of a litany of arbitration cases come out. And I know if you were here with us last year, we talked about that a little bit. We then saw the Walmart Dukes case, which it was a landmark case at the time, and still is. And really, when you look back at it historically and you see what the Supreme Court said there, which they gave the meat to, hey, you need to look beyond just the pleadings here. You need to look deeper and do a rigorous analysis, and you need to overlap your class certification analysis with the merits, and you need to really pay attention. And are these really common issues, or are they individual issues? And we've seen that just come full force. And really is playing itself out today. We then saw the Amkin case come out, talking about, hey, we've got to apply Federal Rule 23 to settlement also, which is very significant. We'll see how that's playing out. And then the Amgen case, which was a securities fraud case. So if you go to the next slide, please, you can see, what are we dealing with right now? I mean, we've seen some surprises with the Roberts Court, as you can tell. I mean, I don't think in the same-sex marriage area, affirmative action, Obamacare, rulings in that area, the court probably hasn't gone the way people thought it was going to go. It certainly hasn't gone the way that the conservatives were expecting it to go, but there has been a constant there. The way the Supreme Court has treated business cases, which goes back to the historical trend that we were talking about. We're seeing, more robust rulings on not just summary judgment, not just motions to dismiss, but on not just arbitration, but on some of these business type things. And so, if you had to bet, you'd say the Supreme Court is going to continue to be kind of in the pro-business arena. And then go to the next slide, please. You can also see there have been some legislative actions. There was a while back in 2005, CAFA was enacted. We've seen some modifications in the federal rules, most recently in 2018 regarding settlement, which we'll talk about in a little bit. And then we've seen some other reform efforts that have stalled. They've been usually put forth by Republicans, and they haven't quite made it out. Probably not going to make it out. I'd be surprised if you saw class actions be a real focus area in the legislature. But all of these things have combined so that if we can go to the next slide, you can see that we now have some changed issues in class actions. These things are different. We've got a rigorous analysis of Rule 23. You've got to look at the facts. You've got to look at the merits. You can't just look at the pleadings. And so the real battle is now being fought at class certification. And all the class action lawyers will tell you, you've got to win that battle. That's where the fight is. And we see this being the predominance piece coming out of the Comcast case that we mentioned earlier, that the Comcast case, you've got to look at these individualized issues versus common issues and what really does predominate there. We've got Article 3 standing issues coming out of the Spokio case that we're going to talk a little bit about. And then, of course, we've seen a slew of cases supporting arbitration. And so all that's different now. That's all different in the last couple of years. So the next slide, please. And here's what we're also dealing with. This Daubert that we talked about many years ago, now courts are looking, does that apply at class certification? If you've got an expert at class cert, do you have to do a Daubert analysis? Most courts are saying yes. That's what we're seeing. Ascertainability. Do you have to be able to ascertain everyone in the class? Or can you have a class definition where you really can't ascertain everybody? And if not, how much? I mean, where's the line? And that's where you're seeing a lot of cases. That's a big fight going on right now. The applicability of the Bristol-Myers Squibb case on personal jurisdiction, all of these opinions are kind of coming together now in the last couple of years so that we're seeing these things changing and evolving circuit by circuit, district court by district court. If you can go to the next slide, please. You can see there's also the big question that I think is going to be out there. What are we going to do with state cases now? State cases, state rules mirror Rule 23 with all the basic things in class actions. And there's almost every state will say, well, we'll look to federal court for guidance on these issues. Well, now you're starting to see federal courts go a much further than some of the state courts have gone. And so it'll be a fascinating issue to see if state courts follow along. So with that table setting there, I'm now going to turn it back to Rick, and Rick is going to talk about some of the trends we've been seeing and what's been happening in the COVID world.
Thanks, Brian. Next slide, please. Yeah, this is just an intro slide, and you'll see this in the data as we look at what's happened for the last 10 years and what's happened in the last 6 months. So let's let's set the table a little bit and develop a baseline. And let's go to the next slide that will show case filings over the last 10 years. Now that is an incredibly busy slide, but it shows us, and even better in the next slide, please, the kinds of cases that have been filed. Now there have been over 45,000, 50,000 class action cases filed since January of 2010. And they break down into several categories, but you can see that the largest single category is consumer protection. And when we look at the results of the cases, you'll find that even though that's where the most cases are, it isn't where the highest dollar amount of judgments have been. But if you look through these, it's consumer protection at about 28,000. That includes the alphabet soup cases, FCRA, FDCPA, FACTA, CCP, RESPA, and other similar cases involving businesses that are regulated by the federal government. And we'll talk more about that later when we get into a discussion of Spokio in the next part of my presentation, followed by securities class action litigation, then antitrust, then insurance and contracts and ERISA. Those are the key business type cases, and then tort, not as many, but the dollars are still in the tort cases. So that's what's happened. So what have the results been? Let's go to the next slide. Another busy chart here, but one that's very useful. And I should say this data is assembled for federal cases using the tool Lex Machina. Lex Machina scrapes all of the PACER databases and gives virtually real-time information about analytics on a particular case, a particular judge, a particular circuit, or a particular kind of case type. This is focused obviously on class actions. So what happens in most of these cases? Well, in 58% of them, the data show they settle or likely settled. 26% are dismissed, but that number is a little bit misleading because within that 26%, as they aggregate the data, 12% go to multi-district litigation. So true dismissals in about 14% of the cases, transfers to MDL in about 12% of the cases. So how many of these cases are actually litigated to a judgment, either before a finder of fact, which could be a judge or a jury, or a decision on summary judgment or on the pleadings? What happens in those cases? 6% of the time defendants win, 2% of the time plaintiffs win. Let's go to the next slide. So why do plaintiffs pursue any of these class actions if they can't get them settled? Well, there's one word, and it's to be billions. These are the damage recoveries in adjudicated cases with plaintiff victories. That means those 2% of all class actions decided in the last 10 years resulted in more than $132 billion in damage awards. Securities leads the list with $52 billion, antitrust $36 billion, consumer class actions, and this is shows that even though they have the largest volume, they don't have the largest adjudicated recoveries, $21 billion, contracts $4 billion, ERISA $3 billion, insurance $1 billion. And although tort should be higher on the list, it's only 4 tort cases that were litigated in federal courts to a final conclusion. They generated $8 billion in damages. So the risk, the length of case, the length of time for case processing, and the cost of defense all make class actions worthy of any business person's attention, and certainly in-house counsel. So is the world today the same as it was on December 31, 2019? For you and me, obviously not. And there has been some change in the class action arena as well. Next slide, please. What we're seeing are an increase in state filed cases, although the data I'm going to show you relates to federal cases. And most of those are in public-facing businesses. So a real pickup in breach of contract, a real pickup in state case consumer protections, as Kurt mentioned, the Missouri Merchandising Practices Act case and similar state laws that give private rights of action, because the focus on many of those cases are particularized not across the nation, but events that were canceled in a particular location, schools that did not return to class or were closed, particular localized events. The biggest national cases, and you'll see this in the next slide, please. This slide is a little bit, also includes currently active cases. So you see a large number of cases in the securities area in this slide, but actual security filings comparing in the first 2 quarters of 2020 compared to 2019 were half what they were. So of that 439 cases, only 176 of them are new, which is a distinct drop. Does that mean securities litigation is going to stop? It's going to not be in the class action arena in federal courts? No. I think that plaintiffs' counsel are biding their time to see what the long-term effect of COVID is on stock prices. So the March drop and the subsequent rally probably blunted the filing of those cases. The largest class of cases that have increased in federal courts are insurance cases. These are claims for business interruption and a variety of other business cases where claims were denied, third-party claims under property casualty, under various exclusions. There's a large uptick there. And then in the consumer protection arena and breach of contract area for refund cases, canceled event cases, and other public-facing claims. So where do we think this is going? Well, let's take a look at the way defendants are defending these cases from the initial 6 months of the year. Next slide, please. Active motion practice, lots of motions to dismiss, lots of motions to stay. Defendants are vigorously defending, throwing every boulder in the road that they can to stop the plaintiff from prosecuting these COVID-related class action cases. So you can see that in this slide. Many of the state cases and the public-facing cases get swept up in arbitration agreements. Motions to enforce arbitration are being filed. And that's one of the things that Brian talked about, and we'll talk a little bit more about the impact of arbitration later in this presentation. So before I turn it over to Brian, we have a couple of polling questions. You've heard a little bit about the law. You've seen the trend for the last 10 years. So here are our questions. One, what best describes your business over the last several years as it relates to being a defendant in class action lawsuits? Since COVID-19, which of those three responses is most applicable to your business? Take your time to answer those, and Brian will discuss them your answers in a bit. Brian?
Thanks, Rick. Appreciate it very much. While we wait for the polling results to come in, we're going to switch here and talk about some of these hot topics, some of the real practical things that are going on in class actions today. And the first thing, I don't know if we had the results on that we can put up there yet or not. There we go. All right, so not a whole lot of effect on most people in our business, in their businesses right now. If you read the news journals and the legal reports, you'll see obviously there are lots of businesses that are getting affected by it, and there are lots of new cases being filed, as Rick pointed out. If you're in a class action, let's talk about some of these things that are out there. First off, I mentioned this earlier, venue really matters. It's where the first battle is made in a class action. Are you going to be in state court or are you going to be in federal court? And even if you are going to be in federal court, if you're facing multiple suits, which circuit do you want to be in? Because the law differs from circuit to circuit. And if you've got multiple cases, you might be able to affect that. And the reason is, and I'll show this, one of the stark examples of this is Judge Harpool out of the Western District of Missouri actually issued an opinion where he said it was a medical monitoring class action. And he actually issued an opinion, said, look, if you're in state court, this case would be certified, but you're not, you're in federal court. And in the 8th Circuit, we're not going to certify this. And so you can see just the stark contrast between where you are. It also will affect your discovery scheduling, whether courts will let you, I wouldn't use the word bifurcate as that's been used historically, but at least the way they'll look at class cert discovery and proportionality arguments versus a lot of states which are still applying reasonably calculated to lead to the discovery of admissible evidence. A lot of states have less robust requirements on expert witnesses. A lot of states have less robust scheduling orders. And then you're also seeing the question that states, they really haven't gotten with the predominance analysis that we talked about on Comcast. And the states have been a little slower to follow along on some of the arbitration pieces. And this idea that we mentioned that came out of the Walmart case about you have to do a rigorous analysis of the factors. In Missouri, there's at least case law out there and other states as well that talk about this. No, you really only need to look if it's been pled properly. You really don't have to look at the facts to see if there's a distinction out there. And then we talked about ascertainability and how that's a battleground as well that really has not made itself into the state courts. And so that a fundamental issue, venue does matter. And one of the areas where we've seen this for sure is in settlements now. We've had amendments on state court, on federal court, federal rules about settlements. And if we could go to the next slide there, please. You can see now we know court approval is required on all settlements, but we've had the amendments that are in place now, and now notice is different. You might be getting notice on your Facebook feed, on your Twitter feed, your Instagram feed. There's provisions about notice. Objectors are limited in federal court. The Cypre award is limited, but you've also, claims made settlements are much more difficult in federal court now. And you've also got a reporting requirement in federal court as well. State court, much more relaxed, much less scrutiny being put on there. We're even seeing in federal court now in the last few weeks, really, that federal judges have jumped in at the preliminary approval stage, which is very early. They did this on the Monsanto settlement. They did this on the Harvey Weinstein settlement and said, wait a minute, I don't think this even looks like I'm going to approve it down the road. And so we're going to stop right now at the preliminary approval stage, not the final approval stage, but the preliminary approval. And I'm going to ask you some questions and have you look at this. And so it's a much more rigorous analysis that you probably wouldn't see in state court. And so that's one of the areas where you're seeing some real differences and some practical changes. Now Rick's going to touch base with you and talk about standing and how standing is affecting class actions as well.
Okay, thanks, Brian. Next slide, please. If you could bring the next slide. There we go. This slide is titled Standing, but we're going to talk about 4 different things, and I'll try to do this briefly. These are really defense tactics, all that are popular and some that are successful. And we're going to lead with the most successful one, and it happens often at the pleading stage. And that is the impact of lack of standing as driven by the Spokio decision. In Robbins versus Spokio in 2016, the Supreme Court addressed the real case and controversy issue in Article 3. So constitutional standing, not just standing under a statute, but what does it mean to have damages? What does it mean to be a qualified plaintiff under Article 3? And in Spokio, the court held that concrete and particularized damages are essential to standing under the Constitution to assert a claim as the class representative. That case was remanded back to the Ninth Circuit. It was appealed again, and the Supreme Court declined to consider the second appeal and stood on its prior decision. So that left the circuits with an issue primarily focused not on particularized. Plaintiffs could particularize their relief, but whether there was concrete injury that entitled them to standing. And the circuit split. Now, recently, the Supreme Court reinforced its prior decision in a June 1 case of this year, Fold versus U.S. Bank. That's an ERISA breach of fiduciary duty case. There was a technical violation of ERISA in U.S. Bank's defined benefit plan. The plan was underfunded. However, the plaintiffs lacked standing because none of their retirement benefits had been affected. And the court reaffirmed its view as to what a concrete damage is. In the interim between Fold and the Spokio case, the circuits were split. The 1st, 4th, 6th, 7th, 8th, 11th, and DC circuits all published opinions that a bare violation of a statute, so this is a plaintiff that may have had statutory standing, did not provide standing under the Constitution, under Article 3. And these were cases mostly in the consumer protection area: FCRA, FDCPA, FACTA, TCPA, CCPA, and RESPA. There are 2 cases in the 8th Circuit that are worth noting, since I know many of our audience will be here. The 8th Circuit was very early on this under the Cable Communications Privacy Act in Breitbart versus Charter. And then that was in 2016. In 2019, the 8th Circuit made an interesting decision in Schumacher versus SC Data Center. That's a Western District of Missouri case. Judge Lowry was the presiding judge. There was a mediation that resulted in a settlement 4 days prior to the decision in Spokio. The defendants moved to dismiss the case because the plaintiff lacked Article III standing. The district court, Judge Lowry, concluded that, well, the plaintiff had standing to enforce the settlement agreement. The Eighth Circuit disagreed and reversed her decision and said standing had to be present or she lacked jurisdiction in the first place. So that was one where there was a technical violation, but not an actual injury. I won't spend a lot of time on the other cases. One that you should take a look at is a March 2020 case. It was a RESPA case decided in the Fourth Circuit, and the Fourth Circuit has an internal split. There was a 2016 case, Krakauer versus Dish, where they went the other way and said under the TCPA, there was no need for the fact of a technical injury or technical default was sufficient to establish injury in a concrete and particularized way. And without reversing that decision, in this Bear versus Krieg North, found that a RESPA violation did not increase any of the costs of settlement of a real estate case and went the other way. So where there are cases where there is where a Bear violation is sufficient, decided in the Second, Third, the Fourth, and the Ninth. The Fifth and Tenth Circuits are uncertain. So let's move on from standing to some other tactics that are used. Motions to strike class allegations. These tend to be more successful after the class is certified if discovery produces information that would indicate that you could strike the class. In many circuits, and especially in district court cases, the district courts typically defer that decision to a decision on class cert. So it's hard to terminate the litigation early on that basis. Limitations on discovery. In most state cases, you can seek the identity of the individual plaintiffs, but the Ninth Circuit in a 2020 decision went the other way and concluded that you can't use your discovery to shop for a better class plaintiff. That case is in Ray Williams Sonoma, a Ninth Circuit decision. And the final point, I'll just, because we're running close to the end here, use of partial summary judgments depends on the circuit, depends on the judge. Many district court local rules give you one shot at summary judgment. But if you can file a motion for partial summary judgment that would reduce the size of the class, take issues out of the case, reduce the damage profile, it's certainly something that should be done and would be a successful defense tactic. Brian, back to you.
Thanks, Rick. If we could go to the next slide there. Thank you. We'll wrap up just pointing out this last hot topic and hot area that's in play. There have been a lot of Supreme Court decisions on arbitration, and we now know that the arbitration clauses really have teeth. And no matter what your business is, if you have a contract, whether it's with the consumer, whether it's with suppliers, whether it's with dealers, whether it's with franchisees, whatever it may be, if you have an arbitration clause, you need to put that on your list of things to review and check on a regular basis. It's really something that warrants being looked at yearly. Or if you just have regular communication with your attorneys, ask them, hey, have there been any recent arbitration decisions? Because there really have been quite a few. And there's one now that's out there, the Henry Schein case. It should be coming out soon, but it's going to talk about things like the scope of the arbitration clause. Is there, what about an injunction? does that have to go into arbitration? What about if you're trying to apply this to non-signatories to the agreement, assignees, and so forth? And so we'll conclude it there. You can tell Rick and I really are into the class action stuff. It's something that we're passionate about. It's something that we enjoy practicing in. There's just so much going on right there in class actions. And really, if you've got questions or if you have things you want to follow up on, feel free to reach out to either one of us. We're happy to talk about this stuff. And we really, really appreciate you spending your afternoon with us in your work from home environment, enjoying seeing Rick in my offices and all the other panelists. So thank you very much for your time today.